Hello, everyone. Welcome to another episode of Steven in 60 Seconds or So. I'm really excited this time around to have Mark Melchers with us. He's an associate lawyer with Cohen Hiley here in town. And there's a really big hot button topic out there, and it's all around the legalization of marijuana and what it really means for landlords, tenants, all sorts of people who are involved. So, what I'd like Mark to do, and I'm going to ask him right now, I want to know, we're going to explore this from two sides. First part's going to be from the owner landlord perspective. And then the next episode we're going to do is going to be for tenants, because obviously there's two sides here. So, Mark, welcome. Thanks for being on the show.
Thank you for having me.
So, give me the landlord owner perspective. What does this new legislation mean on October 17th of this year?
Well, presently, obviously, use and possession of marijuana is illegal. So, under the Residential Tenancies Act, if a tenant were to smoke marijuana, for example, in a rental unit, that would constitute an illegal act, which would contravene the Residential Tenancies Act. Once marijuana becomes legal, there is no specific provision in the RTA which would prohibit a tenant from using marijuana in the rental unit per se, though there are a couple of other provisions of the RTA that could be used to address a situation where it becomes problematic.
So they're allowed, basically, you can smoke marijuana in your apartment building. So if you're in a 17 unit high rise and you want to pull out and do a joint, we'll say, you're allowed to?
Well, it depends on the circumstances, and it depends on what the tenancy agreement says. The Residential Tenancies Act does not allow a tenant to substantially interfere with any lawful right, interest, or privilege of a landlord. And if there is a provision in a tenancy agreement that specifically prohibits a tenant from smoking marijuana, that is a lawful right, interest, or privilege of a landlord. So it would contravene the RTA in that situation, subject to the Human Rights Code.
Okay. So is there any, so if I'm a landlord, can I put in my lease agreement, because let's say we have other tenants who are allergic to smoke, or I just don't want marijuana being smoked in my building. Can I put in the lease agreement, you're not allowed to?
You can put that in a tenancy agreement, and it is in many new tenancy agreements.
Okay. So you can actually turn away a potential tenant because they might tell you through the interview process, yeah, you know what, I smoke marijuana for medical reasons, whatever. You can actually turn away a tenant for that now then.
Well, if it's for medical reasons, it's a different story because that would be a potential human rights issue. If it's not for medical purposes, then yes.
Okay, so even if it is for medical, so I guess a tenant would have to show the landlord, hey, I've got my, I don't know what it would be, a card or a letter indicating I'm allowed to for medical reasons. And I think for the most part, if you're using it for medical reasons, you're probably pretty understanding of it. There's ways to do it and stuff like that. So they would have to show that ideally.
Right. They would have to show some evidence that that is the case. And in that situation, a landlord would have to accommodate the tenant up to the point of undue hardship. So it doesn't mean allowing a tenant to smoke marijuana in their rental unit all day, even if it's annoying everybody around them. But the tenant does need to be accommodated.
Okay. And then if you do bring in a tenant and it does say that you're not allowed to smoke marijuana on the premises, ideally you'd have to go through, if you find out it's happening, I mean, it's a pretty unique smell. Not from experience, but it's a pretty unique smell, is what I have been told by people, just to make sure we're clear on this. If you find that out, then ideally you'd have to go through the eviction process to remove the tenant, I guess.
That's right. If it's in the tenancy agreement and a tenant smokes marijuana in the unit despite that, then you would have to give them a notice of termination of tenancy. It's a voidable notice. So the tenant would basically have 7 days to comply with the notice and stop doing it. If they don't stop, then you could file an application with the landlord and tenant board for eviction. If that notice is voided and it happens again, then the second notice of termination of that type is not voidable. So you could then proceed to the landlord and tenant board.
So there is a process to go through and things you need to look at. So okay, that makes sense.
There, there would be, yes. And there's also another provision of the RTA, even if there is nothing in the tenancy agreement, uh, tenants are also not allowed to substantially interfere with the reasonable enjoyment of the landlord or of other tenants. So even if there's nothing in the tenancy agreement, if a person's smoking marijuana in their rental unit and it's disturbing their neighbors, all the people around them, then it's a very similar situation where a notice of termination can be given. It's avoidable notice of termination again in the same way that the previous one I mentioned is, and you would go through the same process there.
Fantastic. Sounds like there's gonna be more to come on this, and lots of different things are going to surface. We'll say about it. So we'll have to have you back on later on to see how things have panned out. So thanks for the information on the landlord side. We'll end this right now because it's supposed to be 60 seconds or so. So we'll end that now. And Mark, thank you. We'll have you back for the next one. And where can people find you if they want to reach out to you for questions on this?
They can find me at cohenhiley.com or by phone at 226-476-4444.
Beautiful. Sounds great. All right. Thanks, Mark. We'll have you back on for the next one.
Thank you.